inspection violations from 18.
Okay. Good evening, everybody. The July 14th, 2026 Liquor Board hearing is now in session. I'm going to make a move to approve the transcripts from the April 15th, 2026 board hearing as the official minutes. All board hearing transcripts are now stored electronically and served as the official minutes. They can be reviewed online or by appointment with the board office. I'm looking for a second.
I second the motion.
I have a second. All in favor?
Aye.
Aye, so be it. Mr. Hurdle, if you would please, sir.
Thank you, Mr. Chairman. I'm Abraham Hurdle, counsel for the board. At the beginning of every meeting, council makes a few brief announcements. First, the commissioners are part-time public servants and they have other outside interests. When they know they have a conflict of interest, they recuse themselves. They cannot possibly know who will appear from the public in any given matter which may present a conflict of interest to them. If anybody believes that any commissioner or commissioners, as the case may be, has a conflict of interest in any matter, you have to announce that as the case is called, and the commissioner or commissioners, as the case may be, will deal with that accordingly. If not, then the commissioners will proceed with all hearings under the assumption that there is no conflict of interest. Secondly, the rules of the board provide that the chair, for the purposes of judicial economy, can have the board's counsel rule on the admissibility of evidence and objections if counsel is present and objections are made. The board handles many cases at every hearing, and this assignment allows us to expedite the hearings. So rather than the chairman turning to me and me advising the chairman, I'll simply make a ruling, and my ruling will be that of the chair. Chief?
Thank you, Mr. Hurdle. Welcome, everyone. Just a reminder to silence your cell phones if you've not already done so. Our first case is going to be Excel Holdings 7 LLC, trading as Aloft BWI Airport. Shom Amen, member Asada Miriam Cohn, general manager Erica Hart King, employee Chief Inspector Dwayne Gottschalk, Inspector Latasha Beckles, This is for a Class HMR Hotel Motel Restaurant with BWL and Sunday license located at 1741 West Nursery Road, Linthicum, Maryland, 21090 with no restrictions. This is for a violation of the rules and regulations of Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.09A, Relations with Wholesalers, reference to Liquor Board citation number 2202 by Inspector Latasha Beckles, incident dated April 28, 2026. And also for violation of Maryland Annotated Code Alcoholic Beverages and Cannabis, Title 6, Section 6-311B2, titled Restrictions on Purchases and Sales by Retail Dealer in reference to Anne Arundel County Liquor Board citation 2202 by Inspector Latasha Beckles, again, incident dated April 28, 2026. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Yeah.
Solemnly declare and affirm under the penalty of perjury, the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Thank you. If you could state your name and your address for the record, please.
Chief Inspector Dwayne Gottschalk, Anne Arundel County Liquor Board.
Latasha Beckles, Anne Arundel County Liquor Board.
We're missing somebody.
Erica Hart King at Aloft, 1741 West Nursery Road.
Isata Miriam Cohn, Aloft BWI 1741 West Nursery Road.
Eric Von Voorhees of Shulman Rogers for the defendants here. 12505 Park Potomac Avenue, 6th floor, Potomac, Maryland, 20854.
Counsel, where's the licensee?
I beg your pardon?
The licensee?
The licensee got an exemption for today.
We did get excused. Thank you, counsel.
Thank you. I will be speaking on behalf of the licensee.
Thank you.
We good? Ready? Okay, Counselor, thank you.
Inspector?
Okay. On Monday, April 27, 2026, at approximately 5:20, during a routine visit at the Aloft BWI located at 1741 West Nursery Road, Linthicum, Maryland, I encountered Erica Hart King, who was listed as a board-approved manager. I introduced myself and explained that I was on site to conduct a routine visit. I requested access to the alcohol storage room. Upon entering the storage room, I observed multiple cases of beer bearing Total Wine delivery labels. I then asked Ms. Hart King whether she had access to the purchase receipts and advised her that licensed establishments are required to purchase alcohol products solely through the authorized distributors. Ms. King stated that she does not handle alcohol ordering and does not have access to the receipts. I instructed her to notify the licensee general manager that I would return the following day and that the receipts would need to be made available for review. On Tuesday, April 28, 2026, at approximately 12:30 p.m., a team of Anne Arundel County Liquor Board inspectors arrived at the location to further assess the matter. The general manager, Miriam Kong, was present. Chief Gottschalk and I explained the situation and again requested access to the alcohol receipts in the storage room. Prior to entering the establishment, Chief was able to obtain Aloft's purchase ledgers for review from Total Wine. Upon entering the storage room, the previously observed Total Wine alcohol purchase was still present and located in the same area. The inspection team recovered beer, wine, and liquor that had been purchased outside of authorized distribution channels using the most recent delivery receipts obtained from Total Wine, with a total approximate value of $536.71. We completed our investigation without further incident and documented our observation via photograph. The seized products were loaded into the chief's vehicle and transported directly to the Anne Arundel County Liquor Board evidence locker located in Annapolis, Maryland. Pictures, seized receipts, a seized inventory list, the Liquor Board signed notice of seizure form, and the notice of violation 2202 are attached to this report. A violation of Anne Arundel County Liquor Board Rule and Regulations 4.09 was observed during my investigation. We also observed a violation of Maryland Alcoholic Beverage and Cannabis 6-311. That ends my report.
I have nothing further to add.
Counsel, do you have any questions of the inspector?
We do not.
Chairman, any questions?
During the time you were there, Inspector, were they cooperative and with any part of your investigation?
Very cooperative, yes.
They weren't good. Okay. The second trip back, I think that's when the alcohol was confiscated. Is that correct?
Correct.
Okay. And you had Chief Goschalk with you?
Yes.
Okay. Was there anybody else with you and the chief?
Yes, it was 2 or 3 other inspectors with us.
Okay. All right. At any time during your investigation, did they confirm where they got this alcohol from?
Yes.
And they said it was Total Wines and Spirits, I believe?
Yes.
Okay, thank you. Did they state or confess to you that this was a regular routine thing as far as getting it from Total Wines?
It wasn't routine. A conversation was had between Total Wine and Miriam. I think a phone call was made to Aloft. That was what came about this. And she was given some information that made her think that she could purchase the alcohol directly from them, was what was explained to us.
Okay, and you set the record straight as far as making sure they understood how they could legally obtain the alcohol that they were reselling or selling?
We did.
Okay, thank you. I have no further questions at this time.
Commissioner Sung, any questions?
Were there any visible changes in the amount of inventory from the first date and the second day, or was it pretty much the same?
It was pretty much the same. They didn't make any changes. I had explained to Erica that we would be back and not to sell any more of that alcohol. Everything was in the same exact place.
Great. Thank you.
You're welcome.
Counsel, I'll turn it over to you.
Yes, please. So Aloft PWI does not dispute these charges. They admit that they purchased it from a retail establishment. However, the circumstances surrounding the purchase demonstrate that the violation was the product of a good faith misunderstanding of the local regulatory requirements rather than a deliberate attempt to circumvent Maryland's alcoholic beverage laws or to obtain any economic advantage. The manager responsible for the purchase, Ms. Kone here, had previously worked in Montgomery County, where purchases from retail establishments are permitted under certain circumstances that differ from those applicable in Anne Arundel County. Relying on her prior experience of purchasing from local retail suppliers who are licensed to self-distribute in Montgomery County, she mistakenly believed that the same practice was permissible under Anne Arundel County's alcoholic beverage laws. The purchase occurred in connection with a single member's event after the licensee's regular wholesaler advised her that it did not carry a particular products requested for that event. While this misunderstanding does not excuse the violation, it provides important context demonstrating that the conduct resulted from an error concerning the differing regulatory schemes among Maryland jurisdictions rather than an intentional disregard of the law. Upon learning of the applicable requirements, Ms. Kone immediately acknowledged the mistake and undertook corrective actions. Specifically, the licensee has implemented the following compliance measures. All managers and employees responsible for purchasing, handling, and serving alcoholic beverages will be required to be retrained in TIPS alcohol awareness training. Ms. Kone and Ms. Hartking have already scheduled their course for July 27th. Aloft BWI has adopted a written alcoholic handling policy manual now that establishes procedures governing the lawful purchase, receipt, storage, inventory control, and service of alcoholic beverages. I have copies of that if the board would like to see them. Yes?
If you have them,
Yes.
yes. Okay, thank you.
Finally, all personnel involved with the alcoholic service are required to review and acknowledge these policies, and management has instituted oversight procedures to ensure that all future alcoholic beverage purchases are made exclusively from properly licensed wholesalers. These measures are intended to prevent any reoccurrence of the violation and demonstrates Aloft's commitment to strict compliance with all applicable alcoholic beverage laws and regulations. In this matter, the board has seized over $500 in alcoholic beverage inventory. That seizure has already imposed a substantial financial consequence upon Aloft BWI. The Accordingly, should the board determine that additional discipline is warranted, Aloft BWI respectfully requests that the board consider the economic impact of the seized inventory when fashioning an appropriate and proportionate sanction. Finally, for these reasons, Aloft BWI respectfully requests that the board give substantial weight to this mitigating circumstances described herein and pose the least severe sanctions that it's consistent with the purposes of Anne Arundel County's alcoholic beverage laws. Thank you.
Thank you, Mr. Vogt.
Mr. Chairman, any questions?
Yes, I have a couple questions. You said you previously worked in Montgomery County, I believe it was. How long ago did you leave Montgomery County and come to work?
I do live in Montgomery County, so I used to work in Montgomery County
I'm sorry, until when?
2022, sorry. But I do live in Montgomery County.
Okay. You're on the management agreement, which I'm, of course, glad to see. And your tips awareness training, I believe, expires in 2027.
Yes, sir.
That means you probably took the course in the exam in 2023? Does that sound about right? Doesn't have to be perfect.
About.
Okay. And where did you take that?
I took it, it was with the Frederick, the liquor board beverage of Frederick, if I'm correct. I took it with, it was an online class with an instructor, and I have to remember, but it was a couple years ago.
That's fine. You've given me something to think about. I have no further question. Well, no, maybe I do, actually. How many times have you ordered or made the purchases, either through Total or anybody else?
So it was only Total Wine, and anytime that I would not have a delivery or would miss a few items, I would have to purchase from Total Wine, and I didn't know it wasn't allowed, unfortunately.
Okay, thank you. I have no further questions.
Commissioner Sung, any
I
questions?
have no questions.
Is there anything you'd like to say, Mr. Rolls, before I render a decision or at least make a motion? Okay. The two charges, the relationship with the wholesaler and the restrictions for purchases and resale by a dealer, they're not the end of the world, maybe in some of the views and eyes of people sitting out there, but we take it very serious here at the board because this is a way that we get to control, right? Not control the sales, but control how the alcohol is brought in and how it is distributed properly and by law. And when I say by law, I'm talking about not just Anne Arundel County rules, but the state and even in some cases, federal rules and regulations. I understand that there may have been a misunderstanding in this case, but you know what they say about ignorance of the law. I don't have to go into it with you.
Understand.
I'm going to go ahead and make a motion with what I think is a minimal fine. I'm going to make a motion that we find you guilty of both charges with a $500 per charge fine, plus any court costs or administrative fees that would be attached to that. But I'd also like to add a very strict warning. This is not just to the Aloft, but anybody sitting out there who is a licensee, right? You're not allowed to bring in alcohol from another retailer or wholesaler unless it's permitted by law. Okay?
Mr. Chairman, that lesson is learned. They understand completely.
Okay, then that's my motion. I'm looking for a second.
I second the motion.
I have a second. All in favor?
Aye.
Aye, so be it. $500 in each case plus administrative fees. The board will get in touch with you. Thank you. Thank you, ma'am,
Thank you
for
very
showing up.
Our next case is going to be for Corridor Wine Inc., trading as Total Wine and More. Thank you. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand.
Address for the record, please.
Chief Inspector Dwayne Gottschalk, Anne Arundel County Liquor Board.
Good evening, Mr. Chairman, members of the board, Mr. Hurdle, Chief Inspector Gottschalk. My name is Tom Fleckenstein, Fleckenstein, representing Total Wine. Here present with me, and I would point out, and I appreciate the board's consideration today, the licensees were excused, but with me is Mr. Mr. Ken Black and Mr. Andy Weaver. They are the manager and the assistant manager of Total Wine or Corridor Liquor, in this case, Corridor Fine Wine, that were involved in this incident and have the knowledge of this incident. If the chairman pleases, Your Honor, we acknowledge, after some discussion, particularly with Chief Gottschalk,
Mr.
that,
Fleckenstein, my apologies. We're going to read the report first. And then you can-
I'm sorry,
Sorry,
yes.
no problem.
I'm jumping the gun on
Chief
you.
Inspector.
Thank you. On Tuesday, April 28, 2026, at approximately 11:25 hours, I arrived at Total Wine & More to conduct a follow-up investigation regarding potential violations, specifically regarding illegal retail-to-retail alcohol sales. Upon arrival, I met with General Manager Mr. Ken Black, and immediately upon my arrival and prior to any questioning, Mr. Black requested my business card and explained that he had misplaced it, and noted that he had recently identified and denied a sale to an establishment in Howard County attempting to purchase alcohol for resale, demonstrating a proactive stance on compliance. I explained to Mr. Black that the specific reason for my visit was regarding evidence that Total Wine had made multiple deliveries to Aloft BWI Hotel located in Linthicum, Maryland, which is a licensed retailer. Mr. Black was extremely cooperative and immediately provided access to delivery records via his mobile device. The software displayed a history of purchases for an account explicitly named Aloft BWI. The records utilized a specific icon, which was a van with a clock, that indicated that these were completed van deliveries. The purchase history showed a reoccurring pattern of transactions spanning several months. Mr. Black provided me with printed copies of the full delivery order history and the three most recent order inventories dated March 3rd, April 3rd, and April 10th of 2026. During the interview, Mr. Black stated that Assistant Manager Andy Weaver had recently observed an order from the hotel and inquired about its intended use. According to Mr. Black, Weaver was informed by the purchaser that the alcohol was for a last-minute private event and was not for resale. In response to our findings, Mr. Black stated he would be personally re-educating all delivery personnel on the protocols for investigating whether delivery destinations are licensed premises. He also demonstrated the company's Think LP software system, which is used internally to flag and report retail-to-retail violations to their corporate office. He emphasized that their policy is to deny any sales to entities that they confirm are licensed retailers. Throughout the entirety of the investigation, the staff at Total Wine were extremely cooperative and transparent. Mr. Black concluded the meeting by stating he would forward any suspicious names or orders to me moving forward now that he had secured my contact information. Pictures, an emailed statement from Mr. Weaver, seized delivery documents, seized inventory list of what was recovered from Aloft BWI, and a notice of violation number 1673 are attached to this report. A violation of Anne Arundel County Rule and Regulation 4.09, Relations with Wholesalers, was observed during my investigation. I also observed a violation of Maryland Alcoholic Beverage and Cannabis, Article 6-311, titled Restrictions on Purchases and Sales by Retail Dealer. All events occurred in Anne Arundel County, Maryland. That is my statement of facts.
Mr. Fleckenstein, do you have any questions?
I just have one question, and you may have said this and I may have missed it, but it's my understanding that as you were doing the investigation, that you confirmed with the Aloft individuals that they had in fact provided false information to the individuals at Total Wine relative to their intentions with the alcohol that they purchased. Is that correct?
So that is correct. So I was able to confirm from Mr. Weaver, and I have a written statement from Mr. Weaver via email that's included in the violation report. I also subsequently was able to confirm that with Ms. Cohn in person via conversation when she did tell us about the conversation she had with Total Wine staff, and did confirm that it was for a private event, not for resales, what she had allegedly told the Total Wine staff.
Okay. I appreciate it. I don't have any follow-up questions of the inspector, sir.
Mr. Chairman, any questions?
No questions.
Mr. Sung, any questions of the Chief Inspector?
No questions.
Mr. Fleckenstein, I'll turn it over to you.
I'm sorry?
I'll turn the case over to you.
I thank you very much, Mr. Hurdle. As I began to indicate, we certainly understand the board's position on this. Certainly heard the admonition of the prior participants, who obviously were the other side of this transaction. We do acknowledge the technical violation of the Alcoholic Beverages Statute 6-311. When I'm done, I may going to ask you to consider not finding them guilty of the rule and regulation in Anne Arundel County are not responsible. But with that, there's a bunch of information that I'd like to present in mitigation for your consideration, if the chair would allow. So in this particular instance, and I'm assuming the board is somewhat familiar with the establishment Total Wine. Obviously, it's a large establishment, and they get myriad orders on a daily basis. The way this transaction went down is that it was placed online, and it was placed by Ms. Cohn, who I believe was one of the individuals who was here with Aloft with the previous case. The orders are placed online. Total Wine has a system in place where they have what they call the digital team. If there is an order that comes in online that for some reason appears suspicious or raises a red flag or gets someone's attention that perhaps it might be someone attempting to purchase for resale, then they have a mechanism where one of these two gentlemen, whoever's there that day or both, are alerted, and there is some follow-up done to try to ascertain what's going on with the order. And that's exactly what happened in this case. Despite the fact that the order is really not a huge order in the sense that it's one that normally looks to the individuals that it might be somebody trying to skirt the law and trying to get into resale. So what occurred is that Mr. Weaver, I believe, then ended up making the phone call, spoke with Ms. Cohn, as I understand it, and it was advised, no, we're doing a private event. It's not going to be for sale. It's going to be complimentary. They went ahead and filled the order, and then they sent the delivery. Subsequent conversations with Mr. Gottschalk, we came to know exactly the circumstances back and forth. This particular store gets about 1,400 online orders per week. I believe they've got a very good system for trying to catch this kind of thing or any other kind of odd transaction that might come in online. Certainly it should have worked in this instance if they had not been misled. I think, as you probably heard from the prior licensee, in some instances it didn't work, but I can get into that if that's a concern of the boards and address that. And so this is not a situation where, one, my client was not aware of the law, certainly not one where they intentionally or willfully violated the statute or thought, hey, we'll get around this, we'll just send it to them, nobody will ever know. Obviously they've got a system in place that's intended to try to do this. And in fact, it's not uncommon, 2-3 times a week, or I think maybe 2 times on average. I don't want to overstate it. This system catches these scenarios and orders are not filled if they determine through their mechanism that, in fact, somebody is intending it for resale or they really think that that's the case. I can also tell you that since this particular one occurred, that they actually have even expanded how they document these types of orders. When they make a call, if they get information, the internal system that we shared with Mr. Gottschalk, for instance, didn't have everything that at the end of the day turned out to be relevant information for this investigation. But that's now going to be changed. Anything that's called in, any action that anybody takes on any type of order like this is going to be flagged in the system in case it needs to be reviewed internally, or God forbid it needs to be provided here to the board in some circumstance. I can also tell you that the way that these work is that when they get an online order in, it's not like anybody's reviewing it at a large computer terminal or anything like that. It comes up basically on a mobile unit, or sometimes I guess even on a phone, and you can correct me if I'm wrong. And so they're not always getting a big snapshot of everything that's going into an order. And I think they're working on ways to try to make that a little more efficient so that they can review it when it's a suspicious transaction with a little more information. In this particular case, the reason I say it, and again, it did get flagged in this case, but compared to the types of orders that they usually get that raise suspicion, this one was on the relatively small side. It was a total order of about $767. It was mostly beer. There were some bottles of liquor. There may have been a couple of bottles of wine, but I don't believe so. And that's unusual. Normally, if someone is trying to resell, if they're buying from Total Wine, they're buying cases of liquor, cases of wine, cases of beer. And that's not how this one was broken down. I can also tell you that the name that came through on the order, and I have these documents if the board wants to review it, it came in the name of the individual, Ms. Cohn. It did not come in to these guys, and it didn't go out to the delivery person as being purchased by Aloft, for instance. Now, obviously we know that Ms. Cohn, at the end of the day, is obviously representing, and as it turns out, purchasing for Aloft. But even that in and of itself would not have raised any particular suspicion. I can also tell you that their standard policy on delivering any liquor orders that are taken online is a delivery driver has to get an identification from the individual who is receiving the order. Anecdotally, I can tell you I order online from Total Wine on fairly, I hate to admit it, but fairly frequently. And they always insist that there be someone there over the age of 21 to accept it. They've always asked for ID. The driver puts that into a system. In this particular case, when the stuff's been delivered to Aloft, it hasn't been delivered like to a bar area or anything like that. It was delivered to the front desk where an individual, I think sometimes has been Ms. Cohn. In this case, was it Ms. Cohn?
This one was, yes.
Okay, so Ms. Cohn took delivery, gave her their identification, and that's captured in the system. So I think the board should take that into account, is that they really do, in my opinion, have a very good system and do a very good job of trying to catch this type of thing. And like I said, it's not unusual for them to refuse an order that they get a red flag for, and that they are suspicious, and that they do follow up and they find out either that, yes, somebody maybe admits that it's for resale, or they say, we don't believe that it's not for resale, or whatever the circumstance may be, and they deny that order. And I can tell you that those orders have a tendency to be much larger in dollar amount, and obviously a much bigger issue for their business. From my understanding, and I think Inspector Gottschalk indicated that here, I think from the minute that this was brought to their attention, the store was cooperative. I think they very, very promptly responded and provided information. I can tell you that we actually got more information. We're able to find more information based on communications from Inspector Gottschalk that he brought to our attention, which we appreciate. And so the system, I can't come in and say, hey, we're going to do X, Y, and Z now, because the system they've got in place, I think really is, frankly, better than I would venture, I guess, 90% of licensees, particularly large licensees like they are, retail sellers, have in the county. But again, they nonetheless are taking measures to try to make sure that there's more information put into the system when this kind of thing comes up. Certainly, again, we acknowledge that there is a technical violation of the statute, the state statute, at least as the board indicates. But I do think the court can consider that. I think what that statute really wants to prescribe and punish are intentional violations, repeat violators, people who are willfully flouting the statute, things like that. And certainly, I think, and I hope the board will accept my representation, the gentlemen are here to answer questions if you want to hear from them directly, that's not the case with us, that we have systems in place to try to avoid this exact thing. I'm not aware of any prior violation of anything like this with Total Wine. Frankly, I'm not aware really of any violation that I can think of in recent memory, and I've been involved in assisting this establishment for a number of years here in the county, and as I'm sure you recall, been before this board with Total Wine in the past, and there's never been a violation or something like that we've come in. So I think they've demonstrated that they're very good corporate partners here in the county, that they take this very seriously, and that they are, frankly, a top-flight establishment. And I think their cooperation and their willingness to acknowledge that they're perhaps a technical violation of the statute, I hope plays into that. And with that, if I have any other questions, I'm certainly happy to answer them. Absent that, I would ask the board, in light of all of that, in light of their past history, in light of the systems they have in place, in light of the fact that they cooperated so fully, I would ask your honors to impose simply, issue them a stern warning, let's say. And I can tell you that both myself and General Counsel, Mr. Schaefer, who I believe is in the room currently, has also given them a strong admonishment about how to try to do this better. But I would ask that the board find them only in violation technically of the state statute. I would ask that you give them a warning. If you feel under the circumstances that that's not appropriate, and that there needs to be a fine imposed. I would ask you to suspend any fine and allow them to basically continue to demonstrate that they are a top-flight establishment and that this is really a one-off that, frankly, I believe they were as much a victim here as anybody when they were intentionally misled into placing this order when they when they were suspicious and at least put their procedure into place to try to allay that suspicion. And with that, I appreciate it. And so if there's any questions.
Mr. Chairman, any questions?
I do. Thank you, Mr. Fleckenstein. You presented quite the case, quite the ask. I do have some questions for either end or both of these gentlemen. I'd like them to answer the questions.
Okay.
First of all, when Ms. Coney placed that order, she gave the address of the Aloft. Is that correct?
Correct.
So that's okay. You can sit. It's
Okay.
all right. No, that's fine. Please have a seat, Mr. Fleckenstein. Does your system have any way of recognizing that address as the Aloft?
Not specifically as a business, no. It just gives us the street address in the city.
Okay. And the drivers that deliver these, they're the same drivers? Basically, they work areas or regions or?
We have a team of about 10 different drivers at any given time who could take any route depending on what the orders look like for that time slot. So any of our drivers could deliver anywhere within the county.
Okay. When Ms. Coney paid for this order, did she use a personal credit card or how did she do this? How was it charged?
After further research, it was identified that it was a business credit card.
In the name on that business?
Aloft, with a billing address down in Florida. That was after further research looking at our desktop system. That information does not flag on the mobile devices when we're picking them.
Okay, it's a question for either or both. I assume, well, no, I'm not going to assume. I'm asking, have you ever sent an order out to the Aloft before that either of you are familiar with? And please be careful to answer and how you answer.
After further research, we did find previous orders.
Okay, I have no further questions at this time.
Mr. Sung, any questions?
If the hotel were to say place an order for a staff holiday party, would it have raised a red flag, or would it raise a red flag in the future?
If they were using it for a party in which the alcohol was purely for consumption and not for resale, no.
It would not raise a red flag. And you wouldn't know the difference as a retailer. You would not be able to tell.
No, we would reach out to the guest, the customer, and find out what their intentions were with it.
And the reason you would follow up and ask that question is because it's being delivered to the hotel rather than to a home.
To any business. If we identify that the alcohol is being delivered to any business, we would reach out to find out the intention. Even if the address isn't one that we know, but it's clearly a business email address, we're going to take that as a reason to, further investigate.
And would that same procedure apply if the business was a non-alcoholic reseller of a business that doesn't sell alcohol? A law firm, for example. If a law firm ordered, 3 cases of alcohol, would you still make that phone call?
In a lot of cases, yes.
Okay. Thank you.
You're welcome.
Excuse me. Mr. Fleckenstein, is there anything else you'd like to add?
Mr. Chairman, in this particular order, and again, I have the order if you'd like to see it, and bear in mind that all of this information, including the credit card payment information, is entered into the system by the purchaser. This is not an in-store transaction, for instance. Nobody's looking at the person making the payment face to face. it indicates delivery in the order being made by Miriam Cohn. It has the address of West Nursery Road, Linthicum Heights. It has a phone number and it has a zip code. What it doesn't indicate is that it's Aloft, for instance, that it doesn't appear anywhere in the order, nor is there an email that appears in the order. And so, again, they're kind of reliant on the people that are putting this information in that sense. So in this particular instance, like even that in reviewing the order, they would not necessarily have seen that or known that it was going to Aloft until it was out for delivery. And I would also point out that certainly there are legitimate reasons that would not violate this or any other statute where they may be making deliveries to a hotel. For instance, if a guest had placed an order, for instance. I do think, and I think that's a great question, if the hotel is having a corporate event or a Christmas party or something like that, same thing. I don't think it would necessarily raise a red flag, and I don't think it would be a violation, and hopefully we never have to get into litigating this, but I don't think that would be a violation either if Aloft really was doing what they said they were doing, which is having a quote-unquote an event for their members, that type of thing. So I wouldn't necessarily concede that just by virtue of the fact that they're delivering to a hotel should automatically raise their red flag. Now, in this instance, it did, and they reached out. Certainly, and I think it's fair to say that most of the time that they get these things flagged from their digital team, it's really not going to be, it's going to be based not just necessarily on if maybe there's an odd business buying it, but on the nature of the order itself. In other words, what's being ordered, the amount that's being ordered, as I think I mentioned in this case, really not a huge amount of liquor that necessarily would have made them think this is for a big party. And I know you mentioned some prior deliveries, and we did do some additional research in addition, or as a result of the information, but I'll give you an example. Most of the orders that previously went to the Aloft were actually even smaller than this. There was one in early April, $363 total. There was one in March, just over $1,000, $1,013. February of 2026, $684. Here's one from September of 25, $125.30. Those all have the indicia of, and really would appear to be more than plausible that that's somebody who is buying that for a specific, whether it be a personal use or even a corporate use, something along those lines. But most of those transactions, given the nature of what's being ordered and the amounts, would in all likelihood not have even triggered a review. Somebody ordering $125 worth of alcohol, it just doesn't jump out at them as something that's going to be a potential resale. Again, particularly when they're dealing with 1,400 or so online orders a month or a week, and that's frankly increasing. And when they are usually, as I said, when they are flagging orders that appear suspicious, those orders just would not have appeared suspicious.
Thank you.
Thank you.
Questions, Commissioner? All right, I'm getting ready to make a motion, and Mr. Fleckenstein, gentlemen. I do believe that there's some innocence involved in some of this, but I'm having a hard time understanding why an outfit as big as Total Wine and Spirits, and by the way, you run quite the ship over there, can't have a way of doing a checks and balance or a double check or something. Something should have flagged that this was for the hotel. Now, I was an inspector over at Arundel Mills for over 15 years before I changed positions. A lot of hotels, a lot of deliveries to people who are residing, or whether it be temporarily or permanently in those, and they would get their box of wine, case of beer, or whatever, and they could take it up to the room and consume it all perfectly legal. But my concern is not just as much as what took place in this incident, but previous ones, not as much there, because we weren't aware of it and all. But I'm worried about the future. I'm worried about what if Ms. Coney or Mr. Jones calls tomorrow and does the same thing? What, if anything, do you have in place or are putting in place that would prevent this from being sold to a retail outlet?
In this specific case, our loss prevention department has already blocked them from placing online orders.
Okay, well, that's definitely an answer. All right, thank you. I have no further questions, and I'm ready to make a motion if we are. I think Mr. Weinstein put on a pretty good, Fleckenstein, I'm sorry. I put on a good case.
Quite all right, Mr. Chairman. You won't be the last one.
But at the same time, I do believe, not that there was necessarily intention to deceit or deceive the Total Wine and Spirits, but I believe that they are in fact guilty of both the relationship as well as the restriction on purchase and sales. And what I'm going to do is I'm going to make a motion that we have a very minimal fine in both of these cases. But it's more important to me that Total Wine and Spirits understands that they need to do everything in their power to prevent this from happening. This is not the only licensed establishment out there. And I hope Total Wine and Spirits is not sending any of their alcohol to any of these. So my motion is a $500 fine in both cases, a total of $1,000 plus cost, and nothing else. I have a second.
I second the motion.
I have a second. All in favor? Aye.
Aye.
Okay, so be it, $1,000. Thank you very much, gentlemen. Lots of luck. Please be careful out there.
Absolutely.
Thank you very much, sir. May we be excused?
Yes, of course.
Good to see you, Mr. Chairman.
Same
Have
thing.
a great
Mr.
evening.
Same thing with Tom. I'm sorry, wait 1 second.
We're going to postpone this. We're going to call Captain Kids now. And counsel, my understanding is the agent from the ATCC, she is in the hospital with family. So we're going to postpone this matter. I do apologize. I think this is the second time we've been here for this. Postpone.
Is this an expert witness? I mean, I'm just
He's
curious.
more of a fact witness. I would say he's a quasi-fact expert. He is the inventory specialist who did the original bulk transfer list.
Excuse me for a second.
Counsel, I think we're going to postpone the case, and I do apologize that it creates an inconvenience. We'll certainly work with you on a new date. It doesn't necessarily have to be, I mean, we prefer it to be the August calendar, but if it ends up working out better to be in September, we can try to make that work.
Just for the record, may I note an objection and ask for dismissal?
Your objection is noted, it is overruled, and we're not going to dismiss. What I think we're going to do is if he'd like to submit written testimony under affidavit, under this circumstance, we would entertain that testimony.
From
under
my
affidavit.
witness?
Correct.
For the next hearing?
For the next hearing. We would need the licensee still to be here for the next hearing, whenever that is. But we would accept his testimony under affidavit.
Okay. I have a suspicion you'll want to ask him some questions, but I'll talk to
If we
everybody
feel the
about
need
it.
to ask questions, we can certainly come back and withhold a decision at that time.
Okay, wonderful. Well, thank you very much for it.
Thank you.
Okay, thank you.
Sorry for the confusion.
Yeah, thank you. Take care.
But our next case is for K&R Liquors, Inc., trading as Arundel Liquors. Thank you, sir. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand.
Raise your right hand. Do you solemnly declare and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Thank you. If you could state your name and your address for the record.
My name is Zhu.
Yeah, you guys can sit down, just speak into the microphone. Thank you.
Thank you.
My name is Zhi Wu. My address is 223 Beijing Drive, Eastern Maryland, 21601. I'm the secretary of the Arundel Liquor.
Hi, my name is Min Queen Zhang. My address is A530 Fort Small Road, Pasadena, Maryland 21122. I'm owner of the Orlando Liquor Store.
Mr. Chair, members of the board, I'm Richard Bidhart.
Rowan Buddy Marshall, and I run the County Liquor Board Inspector.
And Chief Inspector Dwayne Gottschalk, Anne Arundel County Liquor Board.
Inspector?
So if I may, Mr. Chairman, I just would like to make an objection to the four of the charging documents. The original summons issued for my client's appearance here today list five violations. The last, number 5, being an allegation of 6. 311B1, restrictions on purchase and sales of retail dealers. The ticket that was issued just alleging a count of a violation of 6311, no subsection, and the agenda this evening does not reflect that count. So I would suggest most respectfully that, given that posture, that count can't submit.
We'll withhold that until the end, Mr. Pittner.
Enter general denial.
Thank you, Mr. Pittner. Inspector?
Inspector Rowan Buddy Marshall, activity date was 5/18/2026. The establishment known as Arundel Liquors at 8530 Fort Smallwood Road. This report contains issues discovered at K&R Liquors Incorporated, trading as Arundel Liquors. Licensees Ming, Zhang, and Wu Z, hereafter referred to as Jenny and Paul.
At this point, I'll just make my standing objection to the reading of the
Overruled, Mr. Bittner. Thank you. Please continue, Mr. Inspector.
Following up on an anonymous complaint, Chief Dwayne Gottschalk, and myself conducted surveillance at Arundel Liquors located at 8530 Fort Smallwood Road on Monday morning, 5/18/2026. Approximately 8:10 a.m., we observed Mr. Paul exit the building with a hand truck, which he proceeded to load with 3 cases of Tito's vodka from the trunk of a white car, which had been parked on the parking lot. Upon entering the liquor store with the product, I immediately asked Mr. Paul where the product came from and could we see the delivery invoices. Mr. Paul said he had stored the product at his home in Easton. Then he said the product was left over from a party. Then said he took it home for friends who didn't want it, so he returned it to the store. Since none of these explanations seemed plausible, we insisted on seeing the delivery invoices, which he said he did not have since Jenny takes care of all paperwork and he would call her. Jenny arrived approximately 2 hours later with a new explanation that the alcohol had been stored at another location since she was short of storage space at this facility. After further questioning, she finally admitted that she had made a 50-case bulk purchase along with A-Plus Liquors in Elkridge, Maryland, which is located in Howard County. Ms. Jenny said that A-Plus was storing the alcohol at their location and she would bring it to their store as needed. Upon further investigations, we were advised that the last time they took delivery of any 1.75-liter Tito bottles from a licensed wholesale distributor was back in September 2025. At the conclusion of our investigation, we seized a total of 28 1.75-liter bottles of Tito's homemade vodka with a total fair market value of $844.16 that were unlawfully acquired. Chief Gutschalk took custody of the seized product, transported it to the Anne Arundel County Liquor Board Secure Evidence Locker in Annapolis, Maryland. The licensee was subsequently issued a notice of violation with the following charges: 3.03A records, 4.09A relations with wholesalers, 1-408 record keeping and reporting, 6-311 restriction on purchases and sales retail dealer, and 3.02 cooperation. Inspector Rowan Buddy Marshall, end of report.
Mr. Bittner, do you have any questions for the inspector?
Inspector, thank you. You did not issue a citation for public welfare, is that?
That's correct.
Now, you indicated in your report and your testimony that when you spoke with Paul, none of his statements seemed plausible.
Correct.
And you continue, after hearing that, you continued your investigation.
Well, they didn't seem plausible because he still had not produced the documentation for the purchase of the alcohol.
Okay, I understand that. So you continued investigating?
Yes, sir.
And that's when Jenny came, and then she admitted ultimately that the purchase had come from Junction of A+ Liquors.
Correct.
So nothing that Paul or Jenny said to you or that she dissuaded you from your investigation, you continued it.
That's correct.
And ultimately it didn't frustrate your investigation, you got to the bottom of it.
No, we were very patient and waited for Jenny to arrive, which was a couple hours later.
I don't have any other questions. Thank you. One other question, sorry. So on the charge of cooperation, if Jenny and Paul had not said anything, would you have given them a charge for cooperation?
Well, they still were kind of beating around the bush about the documentation of for the purchases. So that in itself would say that they weren't cooperating with our investigation.
And so I'm just trying to understand the breadth of
No, I understand.
with the cooperation. So if a licensee or an employee of a licensee just doesn't say anything, that constitutes the filing of a charge of cooperation.
I would call that a lack of cooperation since they wouldn't answer any type of questions.
All right, thanks a lot. Thank you.
Mr. Chairman, any questions? Of the inspector, sorry.
Show 311, but you did not show the B1, is that correct? But you also wrote in there the exact wording, which is restriction on purchases and sales and retail dealer. Is that the section that you were referring to when you wrote that on your citation?
The section of the 6-311?
Mm-hmm.
Yes, sir.
Okay. All right. No further questions at this time.
Mr. Sung, any questions?
No questions.
Mr. Bittner?
I don't have any other questions of the inspector.
Your case.
Thank you. So I'd make a motion at this time, if the chairman please, that the count 2 charge 2, public welfare, that charge failed. It's not applicable, it wasn't cited.
My concern, Mr. Bittner, is that the citation as well as the reference document indicates section 3.03, which is for records. It doesn't indicate public welfare. I don't disagree with you, but there's certainly a record-keeping issue here. Would you disagree?
No, we do not disagree. We can see counts 3 and 4, record keeping, lie, and they're in violation of that.
I just want to clarify, because earlier you denied any liability as to this violation.
For the purposes of the record, we entered a denial. Sure. The inspector's testifying and now on argument, if you would, Judge Acquittal, I'm making no argument as to 3 or 4.
So as to violation 2 or count 2, you would ask that that be dismissed?
Yes, public welfare, there's been no testimony of public welfare. I don't believe it's applicable. Public welfare describes the owner operating their establishment in a manner that affects the health, safety, welfare, record keeping violation. I suggest most respectfully doesn't rise to that level. There's been, again, no testimony of how this affected the public.
Mr. Bittner, we're going to dismiss charge 2 of the 5.
Thank you. I'll renew my argument as to count 5, the not providing sufficient notice as to what the allegation is.
That's denied, Mr. Bittner.
I'm sorry?
Denied.
Thank you. As to number 1, cooperation, most respectfully, I'd ask you to dismiss that count. The charge itself, most respectfully, is vague. And as you heard, silence could result in a charge of cooperation for lack of cooperation. We have here before you statements that were made by the licensees that were neither material or relied on by the inspectors. And simply making a statement that's not material, not relied on, not acted upon.
Does it concern you that there were false statements?
Well, so not all false statements are intrinsically material. So again, here we have some statements that may not have been accurate, may not have been correct, but because they weren't acted on, I suggest most respectfully, by the inspectors, it didn't frustrate their investigation. The statement wasn't, false statement, for example, is who robbed the bank? The guy in the red with the red hat. When you knew that it was the guy in the white hat, and then that caused, and here's the second distinction that is that then induces the investigator to rely on that. Then they go running down the street. Here, I didn't believe him from Jump Street.
But the testimony was that he gave these statements and they had to wait for the licensee 2 hours to get the correct story. Correct.
But again, that didn't frustrate their investigation. If they would have been there doing their due diligence, I suggest.
I appreciate the argument. I think we're going to withhold for the chair to make that decision and the commissioners to make a decision. Anything else to add, Mr. Bittner?
No, only that, as I say, the licensees, longtime licensees concede 3 and 4, making arguments. Ultimately, I'll save any further comment.
Commissioners, any questions? Mr. Bittner, anything on mitigation?
Thank you. So I'd ask the board to act only on counts 3 and 4. And I'd ask you to take note that we have before you licensees who've been licensed by this board for some 25 years by review of the comprehensive report. And in that time, they've been before the board only 4 times and only once in the last 5 years, as I read. No previous violations for record keeping. When I was reading the report to my clients in my office, and we talked about, statements, and Jenny was crying. Paul had his head in his hands because I think this is out of their character. It was something, the child caught in the hand in the cookie jar panics, and I think that's what you had here. Ultimately, Jenny confessed, cooperated. The alcohol was confiscated, and I can say with a high degree of probability, I believe this error won't happen again. They're embarrassed. No offense, but they've been amongst the most. The word I want to say, I can't say. But they've been calling me all the time, worried about their business. So they're erstwhile, they're concerned, and I think the board can rely that you're not going to see them back. And I think you can take a lot of solace that you're not going to see them back for anything, because as recently as April the 22nd, they passed a save operation stay. So a very well-run establishment for 25 years, only before you 4 times in very sporadic times, now house and order. So I'd ask you to impose a modest fine on counts 3 and 4.
Chairman, any questions? No questions. Commissioner Sung, any questions?
No questions.
Public welfare, well argued, Mr. Bittner. In reference to the cooperation, I tend to believe that there was some form of deceit that was taking place, and therefore I find that they did not cooperate. Also, with 3 and 4, I also believe that they are guilty of the relations with the wholesaler and record keeping. When it comes to the 5th one, I see your argument, but at the same time, I think the quote 6-311 without the B1 and worded the way it is worded, which is spelled out restrictions on purchases and sales of retail dealer. So I'm making a motion that we find them guilty of 1, and because it's the first time that I know of that they've been charged with cooperation, I'm going to make a motion for a $250 fine for cooperation. I'm also going to find them guilty of charges 3, 4, and 5, and I'm going to make a motion that those be $500 each. So a total of $1,750, I believe that is, plus necessary. Put that in the form of a motion. Looking for a second.
I second the motion.
I have a second. All in favor?
Aye.
Aye. So be it, Mr. Bittner. Good argument.
Gentlemen, thank you very much.
Thank you.
Okay, thank you. Please be careful.
No more next time.
No more?
No more happen. No more
Promise?
happen. Yeah.
Promise?
Thank you, promise.
Okay.
Our next case is going to be for Elite Dining LLC Teapot Restaurant. Thank you. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand.
Declare and affirm with the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Thank you. If you could just state your name, address for the record.
Shang Yang, 2675 Orchard Oriole Way, Oldington, Maryland, 21113.
Conway Chen, 11017 Lunes Drive, North Potomac, Maryland 20878.
Good evening, Mr. Chairman, members of the board. For the record, my name is Linda Carter with Carter Law LLC.
And Chief Inspector Dwayne Gottschalk, Anne Arundel County Liquor Board. Yes. Yeah, that's what I thought. Thank you, sir. Well, Monday, May 4th, 2026, at approximately 14:15 hours, I conducted a site inspection at the establishment located at 2404 Brandon Mill Boulevard, Gambrels, Maryland 21054, currently licensed as Teapot Restaurant. The purpose of this inspection was to verify compliance with the Board of License Commissioners' conditional approval letter dated August 12th, 2025. This approval was based on a proposal to merge Teapot and Crafty Crab concepts into a single seamless trade name. It is important to note that as of this date, the official trade name had not yet taken effect, and a new liquor license reflecting the merged entity had not been issued, as the establishment failed to meet the board's prerequisites. Specifically, the board's approval was contingent upon the establishment obtaining a non-residential tenant improvement permit and ensuring that all branding prevented consumer confusion regarding the existence of two separate businesses. During my inspection, I observed that the establishment was already using or utilizing new interior and exterior signage as well as advertisements that present Teapot and Crafty Crab as two distinct unmerged businesses. This was in direct conflict with the seamless transition concept approved by the board. Furthermore, a records check confirmed that no non-residential tenant improvement permit had been acquired to date, which was a mandatory requirement prior to officially changing the trade name or installing new signage. The inspection also revealed several unauthorized structural alterations that were never submitted to or approved by the board. While the 2025 request from the Carter Law Group stated that, quote, all other aspects of the restaurant would remain unchanged, unquote, except for the bubble tea station, I observed three significant modifications. First, a new wall had been constructed behind a newly altered host stand at the Crafty Crab entrance where a counter previously stood. Second, two additional walls were installed to create a new room or alcove in an area that was formerly a counter extension. Third, a waist-high divider that had been previously separating both sides of the restaurant had been extended into a floor-to-ceiling wall, effectively creating a physical barrier between the two sides. Additionally, the seating capacity on the right side of the building now far exceeds the 14 tables indicated in the May 2025 proposal. These modifications, completed without permits or board approval, further demonstrate the operation of two separate businesses under a single license that has not yet been updated or cleared for such changes. The establishment was subsequently advised to cover up or remove all advertisement, signage, and any other material reflecting Crafty Crab and its logo. Pictures of the observations noted and notice of violation number 1674 are attached to this report. Violation of Anne Arundel County Rule and Regulation 3.13 titled Trade Names, 4.16 titled Unauthorized Conduct, and 4.18 titled Alterations were observed during my investigation. All events occurred in Anne Arundel County, Maryland. That is my statement of facts.
Ms. Carter, any questions?
No questions, thank you.
Chairman, any questions?
No questions at this time.
No
Commissioner Shug,
questions.
any questions? Ms. Carter?
I could approach, please. And I did provide your chief inspector with a copy of this earlier today by email.
Thank you.
At all points in time, my clients have been cooperative, correct?
That is correct.
And you and I had a chance to review the exhibits that I've just given the board. If I could ask those to be moved in, please, as licensees exhibit number 1.
So agreed.
They do, in fact, now have a non-residential improvement permit.
That's correct.
And I've shown you copies, and they're all contained in the exhibit book, that everything that they've done has actually been done pursuant to permits that have been approved by the county.
Correct.
And I also showed you that I believe in April, they received their health department approvals, and as you explained to me, they have to do it again just to add it to the non-residential improvement permit so that it can be finalized. That's all accurate, correct?
That is correct.
Okay, thank you. If I can do this way by proffer rather than taking you through 170 pages. First, as to the name, the board did approve a consolidation of the name. We have for the boards, if I could move this in as licensees exhibit. Every sole reference to Crafty Crab, to the best of our knowledge, has now been either removed or covered up. The buckets that are on the table have been painted, and the paper that had the Crafty Crab logo has been turned upside down. So there's no Crafty Crab per se. So the board may remember what led to our requesting this. When Teapot first opened, the plan was to have the hot pot and Korean barbecue on the left-hand side, and then have a food court on the right-hand side. The food court was not financially viable. My clients bought the building. They've literally spent close to $3 million prior to opening to get this to the point that you all see it. And they were losing, to be quite honest, they were losing their shirt on the food court side of it. So they are the licensees for Crafty Crab at Arundel Mills. They thought the concept would meld nicely. So we came before you, we thought we had worked it out. My clients believed at all times, and I think your chief inspector will confirm that this is his interpretation too, that at all times my clients truly believed that they were doing everything right. When they got that preliminary letter and filed their permits with the county and never began construction until the county approved it, they thought they were on the right path. And then your chief inspector was kind enough to give me a call. I immediately went and met with them, and we tried to make sure that all of the I's got dotted and the T's got crossed. This was never an intent by my clients to snub this board in any way, shape, or form. Now, in terms of the alterations, there is no denying that there are now more seats on what I'm going to refer to as the Crafty Crab food court side than what was originally envisioned, because when Fire came in and looked at the permits, they said they could do extra tables. So they put those tables in, not realizing that just because Fire said it's okay doesn't mean this board has said it's okay. Now, one of the things I'd like this board to keep in mind is this is truly a restaurant. Their food alcohol ratio is roughly 80-20. So this is a restaurant. Their only entertainment are televisions. They don't do any live music. They don't have a happy hour. This is really a place where people go to eat. And in the exhibit book, there are pictures of what they've done on what I'm going to refer to as the Crafty Crab side, the right-hand side. And you can see that the alterations have all been done well. And they spent, to do those alterations, almost somewhere between $150,000 and $200,000 just on that side. So the half wall, there was, as the board may remember, and there are pictures in here that show it, there was a half wall dividing the two sides. In the plans that were submitted to the county, it was always intended to be a full wall. And I don't think I realized it at the time when we asked the board for permission. And I don't know that I even knew that was a full wall until we actually went there and I saw it. But there are still 3 passageways for customers to go through. The bar, which is in both sections of the restaurant. There is a door in the middle, And I have asked them to remove that door unless fire tells them it has to be there. And then there's the passageway from both sides that leads to the bathroom. It is one business. It is an integrated POS system. If you are on the hot pot side, you can order off the Crafty Crab menu. Obviously, if you're on the Crafty Crab side, you can't order hot pot because we don't have the ventilation system and we don't have the heated tables. But it is one business operated by one group of owners and, you know, completely the same. Now, in terms of when you come in, one of the things that your chief inspector indicated was that there is a hostess stand on the right-hand side, the Crafty Crab side, if you will. There was a counter there previously. It was kind of converted into a hostess stand. And there was actually, and I think there are pictures, there was actually a wall behind that. So that wall, it's been modified, but the wall is still there. You said three things. Why am I drawing a blank on the third? You talked about the wall, you talked about the hostess stand. There was one more, and it was...
The alcove.
Oh, the alcove. Yeah, the alcove has always been there, but it just wasn't as defined as it is now. Anyway, we've given you this. This has the original layout. It has the new layout. You'll see that the plans have all been approved by the county. I have also copies of... My clients are very good about sending me things now that they realize they have to. They really did believe that once they had your and this will be 4 and 5, please. Anyway, in summary, Mr. Chairman, Mr. Sung, I can't tell you that my clients abided by the letter of your letter of approval. I can tell you they went through all the proper channels with the county. The trade name registration has in fact been filed. I showed, I think it's in the exhibit book number 1. The mistakes that they made is that they very much wanted to be able to do this because as soon as word got out that a Crafty Crab was coming to Crofton, I will tell you there was lots of excitement. And I think that excitement, I just don't think they realized that there was more to giving this board what you needed than just going through all the county permits. It was not deliberate.
Adamant about leaving the knee wall or half wall.
I don't remember that, Mr. Chairman. I'll be honest with you.
Well, I remember the discussion was it was going to be wide open, so that when you walked in either door, you could literally look on the Crafty Crab side or over on the Teapot side and see over the knee wall. And do we have a
Mr.
record
Chairman,
of that?
I'll be honest with you, I'm drawing a complete blank
Okay.
as to the hearing. I don't remember, this is terrible, I don't remember having a hearing on this.
Okay, let me change the question over to the chief. Chief, did you look at the plans or from the last hearing or the decision from the last hearing when you went out there?
The last hearing, which one are you
Which was
referring?
the original hearing for Teapot.
I don't believe we did it via hearing. I believe it was administratively done, if I remember correctly.
That's my recollection.
Is that what it was?
Yes, sir. I don't remember
I may
having a
stand
hearing.
corrected. Did you look at the notes and everything for that administrative decision?
Yes, sir. And the letter that was compiled and sent out to the licensees conditionally approving it is in the violation packet, I believe. And I believe the Carter Law proposal for that administrative action is also included as well.
Correct, and I don't know that that wall was specifically addressed, Mr. Chair.
Okay. I'm going to let you proceed, but I'm going.
Yes, sir. Correct. It does, and that's what I've told them, to remove that door unless fire says they can't. And I don't know why. It's fully sprinkled, so I don't think that should be an issue.
Okay, I thought that's what you said, Ms. Carter. I just wanted to
Yeah.
clarify that.
No,
For
absolutely.
my understanding.
We talked about that before we approached you this evening. And then there are doors on both sides to get to the restroom, just so the restrooms aren't there.
Understood.
And then there are no doors in the bar section that's in the very front.
Correct. Okay. The signage, has any signage been changed yet?
Changed back. So your sign on top has not been changed yet, correct? Correct. Yeah, the sign on top still just says Teapot.
Okay. The renderings you showed us with the drawings of the signage, that's still the intent?
Yes, sir.
And you know what the schedule might be for that signage to change, or?
Okay.
I'm sorry, I can't.
I'm sorry. No, he was saying that he doesn't know yet because they were waiting for the hearing before they did anything more with the signage. So, because we have to go through, as you know, new permit.
Okay, I have no further questions at this time.
Commissioner Stone, any questions?
I have no questions.
Uh,
In the book.
Ms. Carter, the board's going to withhold a decision and issue a decision in writing. We're just going to verify the record that had previously been issued in terms of the, I guess, previous administrative decision.
Yep, that's fine. Yeah, it's not, there's no, my recollection is the letter of approval, and I do believe it's in here, does not make any reference to that wall at all.
Just want to verify.
Yep, believe me, I understand, but I have to tell you, Mr. Chairman, I'm thinking to myself, I truly don't remember that hearing. I truly don't.
Perhaps that was just.
Thank you so much, and if you all have any other questions, we'd be more than happy to come back and answer them, or I can answer them on behalf of my clients through a letter or email, whatever.
Thank you,
is
Ms. Carter.
easy for the board. Thank you so much. You all have a great and safe evening.
All right, our next case is going to be for AF&T LLC, trading as Kilimanjaro USA. Alphonse Atney, CEO, member. George Fahn, member. Christina Tzak, member. Chief Inspector Dwayne Gottschalk, Inspector Jacqueline also.
Reading. They just don't know it.
Okay. Thank you. Thank you. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand.
Solemnly declare under the penalty of perjury, the testimony I'm about to give is the truth, the whole truth, and nothing but the truth. Thank you. If you could state your name and address for the record, please.
Chief Inspector Dwayne Gottschalk, is Miss Christina Tzak, is she here?
No.
She's not here. So my name is Alphonse. She's not here because we tried to get all right, sorry. I said my name is Alphonse Ate, and I was explaining why the last licensee, Christina Tezok, is not here, because we did everything to see if we could have a certified manager to be there while all of us can come here. I succeeded to get her to the manager to have a certificate of alcohol awareness, which I have here, but we did not fill the application that has to come with the board. So we asked her to stay because if all of us will leave, it will be a violation because she's not there. So that's the reason I'm here with my partner.
Sir, it's the board's policy that if people are summoned, they have to be excused, which is typically pretty freely given prior to the hearing. If they're not excused, the board will cite the licensee for cooperation and postpone the hearing, which would be the case for this violation and the next violation, where she is also required and was summoned to appear. We require all people that are summoned to appear, and if they cannot appear, you have to reach out to the board and ask for them to be excused. If the next time we have a hearing on this, you ask for her to be excused or for someone else to be excused, and the board grants that, they don't need to appear. That was not done in this instance. The board's policy is to cite the licensee for a lack of cooperation, for failing to appear, and to reschedule the matter for the next available date.
All right, I would say this is my first time to have a hearing.
And sir, I completely understand and I sympathize with you. What I will tell you is that even though you don't have an attorney, this rule has caught off any number of attorneys who come before us on a regular basis. You would not be the first person, and there are attorneys who appear before us who have been cited for this as well, for the same issue.
All right, I really understand, and I'll go with your recommendation.
So this matter and the next matter will both be postponed to the next available hearing date, and you'll be brought back in. If she cannot attend, or if one of you cannot attend, which can happen for any number of reasons, whether it be an emergency or for travel or whatever, reach out to the board about a week ahead of time and ask for that person to be excused and give a reason why.
Yes, sir.
Okay?
That's clear.
Thank you, gentlemen.
Thank you. So we'll wait for the next hearing date?
We will send out, correct, we'll send out new information.
All right, thank you, I appreciate that.
Thank you, gentlemen.
All right, our next case is going to be for Skipper's Pier LLC, trading as Skipper's Pier. David Rasaj, managing member, Jessica Rasaj, member, Inspector John Maloney. There are restrictions on the license. One placed 4/25/2000 that the licensees post a sign indicating their patrons are not to park on Drum Point Road. That is a tow and ticketing zone area, and that they are not to park on the grassy part of the marinas lot, and no open containers to be taken off the property. The second restriction, 4/25/2000, music will be restricted as follows. Live music on Saturdays, Sundays, and holidays from 1 p.m. to 8 p.m. Recorded music may be played to 8:30 p.m. on Saturdays, Sundays, and holidays. And the third restriction, 4/25/2000, Monday through Friday, only recorded music will be permitted and will end at 8:30 p.m. All music, whether inside or outside, live or recorded, must be kept at or below the state's noise level of 65 decibels. This is for a change of officer and a request to remove restrictions. Currently, David Rasaj, managing member on behalf of Skipper's Pier LLC, trading at Skipper's Pier located at 6158 Drum Point Road, Deal, Maryland, 27751. This is a Class B restaurant with on-off sale, BWL dancing Sunday license with outdoor service. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Thank you, sir. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Please be seated and state your name and address for the record, please.
My name is Dave Rossage. My address is 302 Highview Road, Tracy's Landing, Maryland.
Thank you, sir. Mr. Ertl?
Sir, I'm going to turn the case over to you.
I'll start. In January, you fine folks have granted me a license, which I was very excited about until the day I went to go pick it up. I was very busy that day. My wife was at Sam's Club. She said she would be happy to pick up the license, to which I responded, well, honey, you can't. You're not on it, which got me in quite a bit of trouble. And so she demanded that I sign up for this hearing and attend today. So I'm here to first ask for her to be added to the license. She couldn't be here today. It was my daughter's 10th birthday, which she's in Ocean City celebrating a girls' weekend at her request, also to her father's chagrin. But that's the first request. The next two requests are in regards to restrictions on the license. The restrictions on the license were put in the year 2000 when I was in high school. They were very rowdy back then, didn't follow all the rules. 10 years after those violations, I took over the operation. For the 14 years that I've been there, we've had no violations during that time of any kind. I feel like we run a very respectful, good community operation, but it's not fair that we have restrictions on music that our competitors and other restaurants in the area have. You know, they're doing music on Friday nights, which I cannot do. They're doing music after 8, which I cannot do. And I'm asking that you remove those restrictions. Also, there was some talk about parking on there. There was a parking problem. The restaurant doesn't have enough parking for the size of it. But after those violations and restrictions were put on, the landlords of the property bought the marina down the street for the express purpose of having additional parking. So parking is no longer an issue like it was in those days, way back when. So those are my requests.
Okay. What are the hours you're looking for?
I would just like a clean license, honestly, because everybody else who opened restaurants during the time that I've been there has no restrictions, and I didn't do anything to earn those restrictions. There was maybe bad actors, I think, 4 owners ago. So honestly, my request would be a clean license to start, and if I make a mistake, you can change it later.
I understand what you're saying and what you're asking for, and I'm not laughing at that as much as I'm sure everybody that comes in here would love to say that exact same thing. I guess my first question is, you want the restrictions removed, and I have a question. I wonder if we can bring the inspector up. All right.
Bring up the inspector.
Is that John?
Inspector Maloney?
Would you come up front, please? Just have a seat at the table. Couple quick questions, Mr. Inspector Maloney.
Mr. Aronson, can you, or Mr. Chief?
Melanie, can you raise your right hand, remain standing, please? So I can swear you in. Thank you, sir. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you, sir. You can be seated. Please state your name and employment for the record.
John Maloney, County Inspector.
Thank you, Mr. Inspector Maloney. I'll be with you in a second. I'm going to jump back to you. Do you have anybody here either in support or not in support? Is there anybody here in reference to Skipper's Pier that would like to testify? What I'm trying to do is find out if we have any objections out there, or if there's anybody. Do you have a petition of any type, or either way?
Honestly, I don't think anybody
Cares. Okay. All right. But you see where I'm going with this. I'm trying to make sure that the community is not going to get up in arms because we did something and they weren't notified. You had your sign properly posted? That
Yes,
was
sir.
checked by the inspector, correct?
Correct.
Okay, thank you. Inspector, just a couple quick questions. You heard the restrictions on this place. You're familiar with them, is that correct?
I am.
Okay. Do you know of any reason why this board would not want to remove those restrictions? Okay.
I can't think of any off the top
Good.
of my head.
No,
I mean,
that's where I'm going.
those restrictions were back long before Dave was an operator there.
Mm-hmm.
I had some knowledge of that place 20 years ago, 25 years ago, and it was a pretty rowdy spot. So I think the restrictions were put on that because of some of the issues that they had years ago. And they don't exist today.
Okay, very good. Well, that's really the point that I was trying to make here. Are you aware of anything that would want to convince this board that maybe we should leave a restriction or add a restriction or remove a restriction? And I think you've answered that. Is there anything else you'd like to say in
No, I
reference to
think
this?
I've known Dave long before I was involved with the county as an inspector, and he runs a terrific establishment.
Okay.
Great restaurant. If you're in that Deal area and want to have a great meal, go to Skipper's Pier.
And you're not familiar with any parking problems of late?
I was, no, what David indicated. I knew the owner for a number of years, and he had purchased a marina down just a couple of streets, a couple of houses down from where the restaurant is. And there's ample parking there, and that's part of their parking now. But, you know, years ago, they didn't have that.
Okay. Thank you. Thank you very much. That's all the questions I have for the inspector. Commissioner?
Commissioner Sung, any questions?
Okay, thank you, sir. What's your intent for entertainment?
We would like to do live music on Fridays. I made a list of our competing restaurants in the area, and of the 4 local restaurants, all 3 of the 4 have live music except us. And we feel it's a disadvantage to us that all of our competitors, many that started after us, are doing music on Friday nights, and we cannot. And then Saturday nights, I would never push it that much later, but I would like to have it past 8 o'clock on certain occasions. 8 o'clock is pretty early for Saturday night, in my opinion.
So you would be okay if we put a restriction on the music, or in your case, I think you have a dancing. Yes, dancing as well as outdoor service. So we just need to be careful and cautious that we don't open up a can of worms or allow something to go awry, and then we're going to have a hard time putting that worm back in the can.
Yeah.
Would you be open to the board allowing your outdoor service to continue, but anything in reference to entertainment, dancing, music, anything, and of course with dancing you pretty much have the full gamut, restricting that to no later than 8? Is that what you just said, 8?
No, that's what it is currently. I
Oh,
feel
that's
like
what it is.
I feel
What
like
would
there's
you like
still.
it to be?
I think 10 would be a guaranteed never have an issue. I I could still do it indoors, right? I mean, this,
Yes.
yeah,
I'm more concerned about outdoors, the neighbors. you
right.
know. Okay. Any suggestions, Commissioner, as far as your view?
The inspector,
Mhm.
I think 10 o'clock sounds reasonable to me.
And I agree with the Commissioner, so we're going to do that. We're going to go ahead
I
and
appreciate that.
remove all the old restrictions, the ones that were put in April 25th of 2000. But we are going to put a restriction on there that all music must cease outside no later than 10 p.m.
I think that's very reasonable. I appreciate that.
Okay, so I'm going to go ahead and make a motion. I'm also going to make a motion that we put your wife on that license.
Thank you very much.
What's the old saying? Happy? Right.
They never told us how hard it would be.
Well, you tell her we're glad to put her on there. Okay? And hopefully you never have any problems, because if you do, guess who's going to be sitting next to you at the table? So, all right, my motion is to go ahead and grant the transfer and remove the restrictions, but add a restriction that no outdoor music can occur after 10 p.m.
I
Looking
second
for
the
a
motion.
second.
I second.
Thank you very much, Commissioner. I have a second. All in favor?
Aye.
Aye. So be it, sir. Enjoy it. Please protect it.
Thank you. I'm grateful.
Oh, I'm sorry. There is one more question. Do you or your wife, either of you, have a financial interest in any other alcoholic establishment in the state of Maryland?
No.
Okay, very good. Thank you.
Okay, our next case is going to be for Access Hospitality Group LLC, trading as Farm and Flame. Naveed Syed Nasrallah, member. Hakeem QR Sandhu, member. Inspector Jim Curazaglo, no restrictions. This is for a transfer and downgrade class. Currently, Steve Shu, authorized on behalf of GTP Licensing LLC, trading as Lodge Pasadena, located at 20 McAtee Beach Road, Pasadena, Maryland, 21122. This is a downgrade to class from BLX Deluxe to a Class H restaurant, BWL, with entertainment, Sunday license, with outdoor service. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Raise your right hand, sir. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do. Please be seated. Can you please state your name and address for the record, starting from my left?
Kiera Wheatley, Wheatley, attorney on behalf of Access Hospitality Group.
Akam Sandhu, 324 Highland Drive.
Yeah, Naveed Syed Nasrallah.
Address?
Address is my own. It's 7916 Lewinsville Road, McLean, Virginia, 22102.
Thank you. Mr. Erdl?
Ms. Wheatley?
Sure. If it's okay with the board, I'll go ahead with the proffer statement just to help wrap this up as quickly as we can. Good evening, members of the board. Again, Kiera Wheatley on behalf of the applicants, Naveed and Akam, both members of Access Hospitality Group. This matter is a transfer application concerning a Class BLX license with entertainment, Sunday service, and outdoor service privileges. It is previously known as the Lodge Pasadena. It's located at 20 McAtee Road, Pasadena, Maryland. And there are currently no restrictions on the license. The applicants have properly submitted a transfer application for the license. The existing license is a Class B, as noted on the application, the agenda, and from the Chief Inspector, we are looking to downgrade that license from a BLX to a Class H license, just because this is not a typical restaurant group, large restaurant group that would hold a BLX license. This is just a standard restaurant. It's the first and only Farm and Flame restaurant of these applicants. So I'm not aware of any rule in the Maryland Code or the regulations that would prohibit that downgrade, so we would ask for that tonight. I'll proffer the sign was posted on July 1st by Naveed and Akam. The sign remained posted for the mandatory 10 consecutive days prior to this hearing. And the inspector inspected the sign on July 2nd. So it's our understanding that adequate notice has been provided in accordance with the rules. Just as a matter of housekeeping, the floor plans that were originally submitted with the application were those of the Lodge Pasadena. Those floor plans were supplemented just to include the new name of the restaurant, Farm and Flame, but the layout of the restaurant stays the same. They are not making any substantive changes to the layout. The seats will not increase or decrease, same size as it has always been. So I just wanted to make sure that the board has received copies of that floor plan. If not, I have copies today. That's okay. I just wanted to make sure that you all had copies of the updated floor plan that were incorporated into the record. Do you want extra copies? Sure.
Wheatley, we were just checking that, are we transferring the BLX or kind of more applying for a new H to substitute the BLX?
It's a transfer.
It's a transfer and then
Yeah.
and downgrade.
It's a transfer with a downgrade, correct? And we're okay to proceed as that application, correct?
Absolutely.
Okay.
Thank you.
Since we are here for a transfer, the board will be determining whether or not the applicants here tonight are fit to hold the license in question. The applicants, Naveed and Akam, are here with me tonight. They have extensive background in the restaurant industry that demonstrates that they are fit to hold this liquor license. In addition to the statements made on the application, I'll proffer on behalf of the applicants that Naveed has been working in restaurants for the past 20 years. He has been employed as a general manager of 2 restaurant establishments, both of which served alcohol and assisted with the day-to-day operations of those restaurants. This will be Naveed's first liquor license that he will hold as a licensee and have a financial interest in. So he does not hold a license anywhere else in the country or state of Maryland, nor does he have a financial interest in any other liquor license. Correct.
Yes.
This is Mr. Yep. Yes, and Akam also has been working in the restaurant industry. She's a franchisee and manager of, for the past 8 years, of Subway's and Barrio Burrito Bar. This will also be her first liquor license that she has held and have a financial interest in. So she does not hold any other interest in any other liquor licenses. The Farm and Flame will be similar to the Lodge in that it's a fine dining restaurant experience. The cuisine is described as Indian American fusion, which I'm personally very excited about. The restaurant will host indoor and outdoor dining as the Lodge did before, with the same entertainment privileges that they have. Again, floor plans are not changing. And the restaurant's bar is just your standard bar to serve a restaurant. It's not a bar that will be generating a late night crowd or anything like that. The focus of it is that fine dining experience. Both applicants are certified in alcohol awareness training. They will provide proof of that training upon issuance of the license. The applicants are both aware that a management agreement would be needed so that another individual is authorized to oversee the alcohol service during operating hours if there comes a time when no licensee is present. The applicants are both additionally aware that upon becoming a licensee, they would be responsible for any liquor license violation committed at the premises and would need to be the individuals that answer to that violation. The applicants have been provided a copy of the latest publicly available version of the board's rules and regulations, and they have reviewed those and are familiar with those rules. And that concludes my proffer for the night. With the board's permission, I'd just like to ask a few questions to the applicants to
Please do.
clarify that
Yep.
the proffer was accurate and complete. So Naveed and Akam, is the application and all supplemental documents that have been submitted to the board true and accurate?
Yes.
Has my proffer of your testimony to the board been accurate and complete? Yes. Have you received and reviewed a copy of the board's rules and regulations pertaining to the service of alcoholic beverages? Are you currently certified in alcohol awareness training? Yes. And will you maintain that certification throughout the duration of your, as licensee for Farm and Flame? Yes. And will you at all times have a person on premises who is certified in alcohol awareness training? Yes. Mr. Chairman and members of the board, that would conclude our testimony case for the night. So unless you have any questions, we would submit and we believe it meets all the criteria to demonstrate that these applicants are fit to hold a license. We would ask you to approve the transfer for BLX to the Class H.
Okay, thank you, Ms. Wheatley. Well done. I have no questions.
Commissioner Sung, any questions?
I have no questions.
Okay, and with that being said, I'm going to go ahead and make a motion that we do allow the transfer and the downgrade. Looking for a second?
I second the motion.
I have a second. All in favor?
Aye.
Good night.
Thank you very much.
Job well done.
I hope to see you all there.
Yeah. Thank you.
Okay, you're welcome. Good night.
Our next case is going to be for TAJ & Co. LLC, trading as Hammer and Nails Annapolis. Stephen Frid, member, Inspector Scott Harmon. It's for a new license located at 2574A Solomon's Island Road, Annapolis, Maryland, 21401. This is a Class SL Salon, BWL with Sunday license. Anyone wishing to testify for or against, please come forward, remain standing, or raise your right hand. Thank you, sir. Do you solemnly swear and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please be seated and state your name and address for the record, please.
Thank you. My name is Stephen Frid. My address is 3301 Churchill Farm Road in Davidsonville, Maryland, 21035.
Thank you, sir. Mr. Ertl?
Durham, turn it over to you to present.
Thank you. So, good evening. My name is Stephen Frid, and I am the member of Taj & Company, LLC, doing business as Hammer and Nails Annapolis, located at 2574A Solomon's Island Road in Annapolis, Maryland. Hammer and Nails is a professional men's grooming business offering barbering and related licensed grooming services. Alcohol is not the purpose of the business, and the shop will not operate as a bar, restaurant, nightclub, or place where someone can come solely to drink. The license will allow us to provide a limited hospitality amenity to eligible adult customers during a grooming visit. I will be actively involved in the operation. We will check identification, use measured servings, train staff, secure inventory, refuse service to anyone under 21 or anyone appearing impaired, keep consumption inside the licensed premises, and follow the law and any conditions imposed by the board. I respectfully request approval of the application.
Hey, Mr. Frid, just a couple questions. Where do you plan on serving this alcohol? Is it going to be in the, is there a waiting area, or is the seating waiting for to get a grooming, a haircut, or whatever?
Well, it would be served initially in the front, in the sort of waiting area. But if a customer wanted to bring it back to their area where they're receiving a service, that would be a lot as well.
Yeah, I wouldn't want to lose any of this in that, but yeah, no. All right, I heard that. Okay, you do understand that you cannot have a bar. Excuse me. A bar?
Oh, yes, correct.
You don't intend on having a table or anything acting as a bar?
I don't believe so, no.
Okay, you don't believe so? I mean, what's your intent? I mean, are you going to have alcohol on a shelf, and when somebody requests something, then pour the?
Oh, yes, just on a shelf. I more or less refer to it as a lounge. It's just a seating area at the front of the establishment.
Okay. You're familiar with how much alcohol you are allowed to serve with this license?
My understanding is that it's an option of one drink for a service, not per service. So it's one 12-ounce beer or one 5-ounce glass of wine or one serving of 1.75 ounces of liquor.
Okay, thank you. I have no further questions. Okay, with that being said, is there anything else you'd like to say before we rule?
No, just thank you for having me. I appreciate being almost last in this, so I know exactly what not to do. I'd like to thank you all for that. I appreciate you taking the time.
There is a benefit to that, so hopefully, we won't see you here any earlier. And every one of those gentlemen and ladies over there learn every time they sit in that chair. They hear about the different violations and the different cases and the different situations and what you can and can't do. And I know a lot of people sitting in the audience, if you want to call it that, also. I'm going to go ahead and make a motion that we accept the new license as requested. It's a Class SL salon for beer, wine, and liquor with Sunday privileges. Looking for a second.
I second the motion.
I have a second. All in favor?
Aye.
Aye. Okay, sir, congratulations. Please, yeah, be careful.
Thank
Thank
you.
you.
All right, last but not least, Yummy Bowl, Glen Burnie LLC, trading as Yummy Bowl Glen Burnie. Yu Feng Zheng, owner, Inspector Chris Sidebottom. This is also for a new license located at 7385 Baltimore Annapolis Boulevard, Suite G, Glen Burnie, Maryland, 21061. This is for a Class H restaurant, BWL, with background, entertainment, and Sunday license. Anyone wish to testify for or against, please come forward, remain standing, and raise your right hand. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Please be seated and state your name and address for the record and to the mic. Name and address for the record.
Haiyan Wu. Address, you mean store address or my own address?
Home address.
My living address? 955 Havana Avenue, Philadelphia, Pennsylvania, 19006. Haiyan Wu.
My name is Yu Feng Zheng. The address 7235 Baltimore Annapolis Boulevard, zip code 21061, Grand Bonnie.
Thank you. Ms. Hurdle?
Ladies, we're going to turn it back over to you to present why you should get the license. Why would you like a license?
Just comparing some sales with some customer wanted. Not on main sale because we was very strong.
What are your proposed hours?
We was 11 to 9:30 on the Monday to Tuesday. Monday, Tuesday, Wednesday, Thursday. Friday, 11 to 10. Only Friday and Saturday. And Sunday was 11 to 9.
Okay. You are Miss Feng, correct?
He's the owner. I'm manager.
Okay, all right, that's what I'm getting at. You're Miss Feng, F-E-N-G, correct?
Yeah, Y-U-F-E-N-G.
Okay, all right, very good. Ms. Feng, do you have any interest in any other establishment, any other place that sells alcohol in the state of Maryland?
No. No.
Okay. I have no further questions. Commissioner?
I don't have any questions.
Okay. All right, ladies, as brief as this is, we're going to go ahead. I'm going to make a motion that we accept your new license, and I'm looking for a second.
I second the motion.
I have a second. We're going to go ahead and grant it. All in favor?
Aye.
Aye. We just granted you your license. Please be careful. You heard what happened tonight with a lot of these cases, so please beware. Be careful when you serve people. Make sure they're old enough. Okay? Yes. Have a good evening. Yes, you're good.
If you have any questions, ask the staff.
Yeah. That's the happiest I've seen anybody leave here. Okay. All right. This hearing is now over. Thank you all. Have a good night. Drive careful. Be safe. And it's 8 o'clock.